Hey everybody. My presentation will be on Chapter 11 bankruptcy, and specifically there's a safe harbor clause that prevents certain transfers from being undone by the bankruptcy trustee. And the bankruptcy trustee would want to undo certain transfers so that they do not have to pay for transactions that were agreed upon right before the bankruptcy company went insolvent. And the subsection that has the safe harbor clause is section 546E in the bankruptcy code, and it states, the trustee may not avoid a transfer that is a margin payment or a settlement payment made by or to a commodity broker, a forward contract merchant, a stockbroker, or a financial institution. And financial institution is going to be the intermediary that is specific and relevant to this case. So some facts on the case. The FTI Consulting Inc. is being sued by Merit Management, and Merit Management is a 30% shareholder of Bedford Downs, and FTI Consulting is the bankruptcy trustee from Valley View Downs. Valley View Downs was a horse track, and Bedford Downs was a horse track as well, and they were competing for the last harness racing license, and that is essentially the same thing. It's a license that says that you can have horse races in the state of Pennsylvania, and so instead of competing for it, they made an agreement that Valley View Downs would buy Bedford Downs for $55 million. And the ultimate goal of this consolidation was to have a horse track and a casino. So Valley View was going to get the $55 million in funds from Credit Suisse in order to fund this acquisition. And Citizens Bank was going to be the holding bank that transferred titles and was dealt with escrow. Ultimately, Valley View did obtain the horse racing license, but they failed to get the gambling license. And so as a result, Valley View had to file for Chapter 11 bankruptcy. So here's where FTI comes in. Now that Valley View has filed for bankruptcy, FTI is trying to deal with the payments that it has to make to creditors. And so FTI is saying that the transaction of the $55 million, it should not have to pay for the 30% stake that Merit owns, which is $16.5 million, because the transfer did not include financial institutions. And while there was financial institutions that were involved in the transaction, they sucked no gain or loss, and they were just merely acting as conduits into the transaction. And so FTI is saying that because the banks were just conduits, that the safe harbor defense has no application. And so if this safe harbor defense does not apply, then as stated earlier, FTI would not owe Merit Management, who was a 30% stakeholder in Bedford Downs, their share of the $55 million, which equals $16.5 million. So Merit's argument is saying that that the court should look not just at end-to-end of the transfer, which would be from Valley View to Merit, which both do not apply to the safe harbor clause because they're not financial institutions, but that the court should also look at all of the components, and that includes transactions, and that includes transactions by and to financial institutions. And so what Merit is saying is that even though that no financial institution, the two banks, were going to gain anything from the transfer, that the court, or that the transaction used the banks to facilitate the transaction, and so that this safe harbor agreement does apply. And just to reiterate, if the safe harbor agreement applies, then FTI would not be able to void the transaction. So Merit is saying that they should still be owed $16.5 million. So after hearing all the facts, the court decided that FTI was correct in that even though banks were used to facilitate the transaction, they were merely used as conduits of the transaction. So the courts decided to focus on the end-to-end transfer of the horse track, and so as a result, FTI was not required to pay the $16.5 million to Merit. And the reason that the court said this was that they wanted to maximize the funds available and ensure equity in the distribution to creditors in a bankruptcy proceeding, and that the bankruptcy code does give the trustee the power to invalidate a limited category of transfers by the debtor. And this is an example of a transaction that the trustee of the company that's in bankruptcy, they can invalidate this transfer because this safe harbor agreement does not apply. So in the end, FTI was able to get out of paying the Merit management the $16.5 million that it was owed, and that money will go to creditors that are owed money after the Chapter 11 bankruptcy is complete. And this decision was reached in February of 2018, so this is a relatively new decision, and I think it is confusing at times because there's so many moving parts, and there's the safe harbor agreement, but I think it does incorporate a lot of topics that we discussed in class. And overall, while it was challenging, it was pretty interesting to find out to follow the case and figure out what the courts decided. So thank you very much for listening to my presentation.